Imagine waking up one morning and finding out that the most popular rifle in America, the AR-15, has suddenly been declared outside the protection of the Second Amendment. Imagine hearing that from this point forward, simply possessing that rifle would no longer be lawful, regardless of the fact that millions of people have legally owned them for years. That is the type of reality many states and local governments have been trying to push into existence. And that is exactly why we are once again facing a massive showdown in front of the United States Supreme Court. For years now, the battle has been brewing in state houses and city councils, with lawmakers insisting that sweeping bans will somehow lead to safer communities, while millions of ordinary citizens feel like their rights are being chipped away piece by piece. The clash between those two perspectives is what makes this moment so explosive. The question that now sits before the highest court in the land is simple but critical. Are bans on rifles, like the AR-15, constitutional, or should they finally be struck down nationwide once and for all? If you are following along here, it means you care about the Second Amendment and you care about your rights. And that is important because even law-abiding gun owners can end up in serious legal trouble often without even realizing that they have stepped over a line. Many people do not fully understand the laws around firearms, and mistakes that seem small can turn into years behind bars. That is why this current challenge is not just another routine case. It is something that could define the future of gun ownership across the country. The case that has now made its way back in front of the Supreme Court is called Viramontes v. Cook County. The petitioners here are ordinary citizens joined by major organizations like the Second Amendment Foundation. They are challenging Cook County's ordinance that makes it a crime to sell, transfer, or even possess what the county labels assault weapons. That definition covers AR-15s, AK-47s, and roughly 100 other types of rifles and platforms. This is not just some symbolic ordinance without teeth. Violating the ban means you risk having your firearm seized, facing steep fines starting at $5,000 and going up from there, and even the possibility of jail time. What makes this case even more pressing is that it is not being argued in a vacuum. Petitioners are leveraging recent statements made by Justice Kavanaugh when the court denied review of a different rifle ban case just last term. At that time, Justice Kavanaugh indicated that the day would soon come when the Supreme Court would have to confront these rifle bans head-on, perhaps even along with challenges to magazine bans. Now the plaintiffs argue that Viramontes is the perfect vehicle for the court to fulfill that promise, step in, and deliver a clear ruling on whether or not these types of bans can stand. Back in 2021, this lawsuit was first filed in a federal district court in Chicago. The petitioners brought their challenge against Cook County's ban under both the Second and 14th Amendments. While this case was pending, Illinois went a step further. In 2024, the state passed its own statewide assault weapon ban, officially titled the Protection of Illinois Communities Act, or PICA for short. That law overlapped with Cook County's ordinance covering many of the same rifles and restrictions. The overlap created confusion for residents who were already struggling to understand what was legal under county law. Suddenly, the state added its own sweeping restrictions, making compliance even more complicated. Many gun owners describe the feeling of living under constantly shifting rules, where one wrong step could turn them from responsible citizens into criminals overnight. Around the same time, another major case came out of the Seventh Circuit called Bevis v. Naperville. In that decision, the court upheld Illinois' new law ruling that AR-15s were too militaristic in nature. Because of that militaristic quality, the court claimed they were not protected arms under the Second Amendment. The reasoning was striking. The Seventh Circuit essentially declared that firearms commonly used in military service could be banned by states and local governments. They drew a line that said if a rifle resembles or functions like the M16, then it can be excluded from constitutional protection. Using that standard, the court upheld the restrictions, and when the district court looked at Viramontes, it concluded that it was bound by the same precedent. As a result, the district court issued summary judgment in favor of Cook County, leaving the plaintiffs with no relief at that level. Then, in 2025, just after the Supreme Court denied review in the Snow petition, the Seventh Circuit moved quickly in this case. Practically the same day or the day after the appellate court affirmed what the lower court had already said. They leaned heavily on the Bevis decision, once again treating AR-15s as the civilian version of M16s, and therefore outside the scope of the Second Amendment. That is how the case has now made its way back to the Supreme Court, with the plaintiffs urging the justices to finally confront this issue and settle it once and for all. The arguments being made here highlight how deeply confused the circuit courts are when it comes to applying the standards from Heller and Bruin. Some courts recognize that AR-15s are arms, but then claim they can still be banned. Others insist AR-15s are not arms at all and therefore not protected in the first place. Petitioners want the Supreme Court to clear this up and to declare that semi-automatic rifles like AR-15s and AKs are indeed arms and protected by the Constitution. Their case is that if the most widely owned and used rifles in the nation are not protected, then nothing meaningful remains of the right to bear arms. The petitioners also brought forward surveys, production numbers, and sales data to emphasize just how widespread these rifles actually are. Tens of millions of AR-15s and similar semi-automatic rifles are in circulation throughout the United States. They are not niche items, they are not unusual, and they are not limited to a small group of collectors. They are owned for home defense, for target shooting, for hunting, and for countless other lawful purposes. If you walk into gun ranges across the country, you will see rows of people practicing with AR-style rifles, not because they are preparing for war, but because the platform is versatile, easy to maintain, and widely accessible. Families in rural areas often rely on them for protection against predators or for sport, while urban owners frequently cite the rifle's adaptability for personal defense. In other words, they fall squarely within the category of firearms in common use, which has always been considered protected under the Second Amendment. The petitioners argue that if the Second Amendment does not safeguard the most widely owned rifle in the country, then one has to ask what it protects at all. Cook County, along with the Seventh Circuit, has leaned heavily on the claim that AR-15s are military-style firearms and that their militaristic features make them unprotected. But the petitioners point back to the Heller decision, reminding the court that the test was never about whether a firearm could also be useful in military service. The only historical limitation recognized was on weapons considered both dangerous and unusual. AR-15s are the exact opposite of unusual. They are common, popular, and overwhelmingly used for lawful ends. By focusing on whether a rifle looks like or functions like something in the military, the lower courts have invented a new test that does not exist in Supreme Court precedent. They further argue that under the Seventh Circuit's reasoning, lawmakers would essentially be free to ban nearly every category of firearm, except a narrow selection of handguns mentioned in Heller. This would gut the Second Amendment, reducing it to little more than a suggestion that could be chipped away at every legislative session. If states can say that militaristic features are enough to justify a ban, then the door is wide open to expand those bans further and further, until very little is left. The petitioners also emphasize the climate of defiance that has followed the Bruin decision. After Bruin, which was supposed to clarify the standard for evaluating Second Amendment cases, many states simply pushed forward with even stricter restrictions, daring the courts to stop them. The lack of immediate clear guidance from the Supreme Court has only emboldened those legislatures. Petitioners warn that without a strong ruling striking down these bans, the erosion of gun rights will only accelerate. That is why they say this case is the perfect one. It is clean, it is direct, it is on the final merits, and it is ready for the court to take up right now. At the center of it all, the firearms in question remain the AR-15s rifles that have become known as America's rifle. Petitioners highlight that there is no factual dispute over just how popular and widespread these firearms are. Multiple circuit courts have split on the issue of rifle bans, and millions of citizens are directly impacted by the uncertainty. This is not a localized dispute for Cook County or even the state of Illinois. It is a national question that demands a national answer. Whether someone lives in New York, California, Washington, Oregon, Colorado, or anywhere else, they are confronted by laws that either already ban these rifles or are moving rapidly in that direction. Each of those states presents its own justification, often pointing to tragic incidents or political pressure, but the result for citizens is the same: an ever-growing patchwork of restrictions that make it nearly impossible to exercise rights consistently across state lines. Gun owners who travel or move frequently describe the exhausting task of trying to remain compliant, unsure if the rifle they legally owned in one place suddenly becomes contraband in another. The momentum is spreading, and every gun owner knows it is only a matter of time before these bans touch even more states if the Supreme Court does not intervene. The petitioners stress that the longer the court delays, the more emboldened legislatures become. Each new session brings the possibility of additional bans, each one further eroding the constitutional right that is supposed to be guaranteed. Without intervention, the Second Amendment becomes a hollow promise. The justices are reminded of Justice Kavanaugh's own words, where he indicated that the court would need to step in within the next term or two. That time has now arrived. This is not only about rifles on a list, it is about the principle that the Constitution either means what it says or it does not. If AR-15s, the most common rifles owned by Americans, can be stripped of protection, then no firearm is safe from prohibition. The petitioners present the case as overdue, necessary, and unavoidable. They argue that the court cannot ignore the deep splits among lower courts, the millions of citizens caught in limbo, and the fundamental importance of the right at stake. As this case continues to develop, it will be essential to watch how the justices respond. The decision they make will ripple across every state, affecting every gun owner, every family that relies on these firearms for defense, and every person who values constitutional rights. The Supreme Court has a duty to bring clarity to enforce the precedent it has already established, and to ensure that the right to keep and bear arms is not reduced to an empty phrase. So, as always, stay alert and stay informed. The stakes are too high to ignore, and the outcome of this case could shape the future of the Second Amendment for generations. Make sure you are following closely. Make sure you are subscribed, and never forget that this nation was built by armed citizens, and it will be maintained by them as well. A Chen video trong by Bao Ne Vao Sao https://abc 7 Chicago.com/post/Illinois-assault-groups-ask-use-supreme-court-overturn-cook-county/176-84835/chu-y video c2 che-song vid moi nen lei dung vid dao tien https://print.sc/ql6qac2le7z